All right, hello and welcome again. Disability Law Show. We are back. You are back. Good to have you along for the 30-minute ride. John Scholes here. Beside me, of course, Sivan Tumarkin, Samfiru Tumarkin, LLP, the most positively reviewed law firm in the country. Wondering how to reach out? We'll tell you that throughout the show. 1-855-821-5900. help@disabilityrights.ca. That's the email address we always use. A couple other things you can use as well. mydisabilityquestions.com. It's for exactly that, asking your questions about disability. It's online, it's free, it's anonymous, it's searchable, so maybe your question has been asked by someone before. It'll save you a bit of time, and I know Sivan will refer to ltdfaq.ca. That is for memos on LTD. It's like Lego. Really simple to use, really basic to read, but full of information. We will refer to that later on in the show. And Sivan, 3 common misconceptions about long-term disability claims. That is coming up, but we start with the case of the day, the week that was. Pal, what do you got?
Absolutely, John. Great to be here. Let me start off with something that actually comes up not infrequently, and especially now when we're dealing with rising inflation. This is something that has come to the fore, and that has to do with cost of living increases. And we often get people contacting us, people who watch the show, people who listen to the radio, asking us, look, I've been on LTD for 5 months, for a year, for 5 years. Am I entitled to a cost of living increase, or is the amount that I'm getting from my LTD insurer, my long-term disability insurer, the same and going to remain the same? And John, the answer really comes down to what we always say, which is the obligations of the insurance company to you as the insured individual is rooted in the contract, in the policy. The policy of insurance is the contract, so we have to look at the contract. Now, when you look at some of these LTD policies, some of them contain provisions that allow for a cost of living increase. Right? So, and they will provide you with details about that. What's interesting, however, is that sometimes people who ask us those questions have not been getting a cost of living increase, and when we look at the policy, we see that they're entitled to it. Oftentimes, that's an easy fix. We tell them, look, contact the adjuster, talk to them, and if there's an error, it's usually rectified. Sometimes, though, we have to get involved. So, even though we're talking about cost of living increases here, and I urge anyone who is on long-term disability to look at their policy if they're not getting that, to see if they're entitled to it, right? It's going to be in black and white there. The larger issue here is that if you think you're entitled to something under your LTD policy, look at your LTD policy. If you don't have a copy of it, then ask your adjuster, the case manager, ask them for a copy of your policy, and then have a read through it. Now, by the way, when you read those policies, there's a lot of legal speak and insurance type words in there. And one of the things we've talked about before, John, is that we created a while back a website called LTDFAQ.ca, long-term disability frequently asked questions, LTDFAQ.ca. And if you go on there, you'll see that there are short memos. It's all free. And they provide, the most common answers to the most common questions that we often get. And one of the memos we just added are those common terms that you find in LTD policies that, you're reading the policy and you have no idea what it means. Well, go to that memo and you'll see and it'll explain to you. And of course, if you have any questions about your policy, a family member's policy, you have an issue with your insurance company, feel free to give us a call. It costs nothing to speak to any member of our team.
You always say that everything you're dealing with your insurance company is governed by the policy. Do you get people calling you saying, the adjuster doesn't seem to know this because they're telling me things that are outside my policy. I'm having problems with these folks. You get that all the time?
We definitely get people contacting us, telling us, look, the adjuster is saying that this is what they're asking me to do, or this is what I need to do. And, I don't know if I should be doing that or if I'm entitled to that, etc. For example, a common question is they want me to see one of their doctors for an assessment. Mm-hmm. Do I have to do that? And we say, well, yes, you do. And in fact, if you look at your policy, you will see that there's usually a provision in there that obligates you to do that if they ask you to go to be seen by one of their doctors for an assessment. But again, I want to make sure that people understand, John, that it's not just your obligation as an insured individual, it's also the insurance company's obligations towards you. So that means that they have to pay you if you meet the criteria for long-term disability. It means that they have to do certain things to abide by the terms of the policy. And again, circling back to what we started with, cost of living increases. If you're not getting that, if you're an LTD and you're not getting a cost of living increase, check your policy to see if in fact you're entitled to it. Because if your policy says that you're entitled to it and you're not getting it, you have a right to demand it. And if your insurance company or adjuster says no, for whatever reason, this reason or another reason, you shouldn't be getting it, ask them why. And if it doesn't make sense to you, then contact us. We'll ask to see the insurance policy, we'll talk to you, we'll see the correspondence between you and the insurance company, and we'll tell you what your options are. You know, people out there, John, they're not professionals, right? I mean, they're insureds. They're individuals who are suffering a disability. That's why they're on LTD in the first place. Sure. These adjusters, that's what they do for a living. Well, it so happens this is what we do for a living. We challenge insurance companies when insurance companies act unfairly. And we do this day in and day out. So if you have any questions, you're suspicious of what the insurance company is telling you, contact us. We can look at everything, again, for free, and we'll tell you what your rights are.
In your opinion, or at least in your experience in the past, these cost of living increases, if a client has not been receiving that, say, for years, they've been neglected in that regard. Is it retroactive?
It should be retroactive if they're entitled to it, absolutely. In fact, I talked to a lady earlier this week, 42 years old. She's in Alberta, and has 3 kids. I mean, money is tight. And she has not been receiving a cost of living increase, and her policy, in fact, states that she's entitled to it. Now, if she's going to be disabled until the end of the policy, which in her case is age 65, I mean, you're looking at 23 years worth of potential increases that if she's not getting it, she's going to miss out on, right? And the insurance company has to pay her that. Sure. And if they don't, she has a claim. But typically, John, again, once we clear up these misunderstandings with insurance companies, they pay what they're supposed to, especially if they know that there is a lawyer involved and a law firm like us, right? I mean, they know us. We've developed a reputation with them. But again, check your policy. And the other thing is, don't take what the insurance company says at face value. If you ask your adjuster, am I entitled to a cost of living increase, and the adjuster says no, ask them to give you a copy of the policy, have a read through the policy. If the policy doesn't contain a provision that allows you to get the cost of living increase, that's fine. But if it does, then put that to the adjuster and ask them, well, how do they reconcile their position with what's in black and white in the policy?
Again, Sivan mentioned LTD FAQ. That is a good reference site. There's also pocketemploymentlawyer.ca. Oh, yeah, that's employment. Yes, it is. But there's a pretty robust section on disability law there as well. There's a reason for it, isn't there? There
is a reason for that, John. And the reason is this. Many individuals that contact our firm have issues with their employment. Part of the reason is because they have a disability of some sort. And many of them actually have then a claim for long-term disability or short-term disability for that matter. And many of them find themselves having issues with both their employer as well as with the insurance company, or one or the other. And so that's why when we created the Pocket Employment Lawyer, we created a section in there that allows people to get quick and correct answers about their respective situations. And so if you have an employment law issue, if you have a long-term disability or short-term disability issue, and you want accurate and free answers really quickly, go to that website, the Pocket Employment Lawyer website, and you'll get those answers. And if then, after getting that answer, you want to reach out to us and have a consultation, again, for free, we will be more than happy to speak with you. If you don't, that's fine. You got your answers, close the browser, and we'll never know you were there. But the point is, that's the reason. Our focus at the firm is employment law and long-term disability law. And so that's the reason why the Pocket Employment Lawyer deals with both of those areas.
And the phone number anytime, 1-855-821-5900 to get a hold of Sivan and the rest of his team. We'll grab an email here while we get into our first segment. Before the break, Rhea writes in, and by the way, it's help@disabilityrights.ca. She says, my LTD benefits were cut off after I underwent a medical assessment at the insurance company's request. Though it has been almost 2 years since my injury, my doctor still believes I'm unable to work, particularly due to the medications I need to take. What should I do?
This is very common, John. And, again, we talked before about this idea of the 2-year mark. And many people are very surprised that their benefits are cut off at the 2-year mark. Now, Rhea, what's happened here is that your policy is likely a standard type policy that we see. And what I mean by that is that in those kinds of policies, standard policies, to get LTD for the first 2 years, you have to demonstrate with the help of your doctors that you are disabled, you're unable to perform the essential tasks of your own occupation. Beyond the 2-year mark, to cross that threshold and continue receiving LTD benefits, you then have to demonstrate, again with the help of your treatment providers, your doctors, that you cannot perform the essential tasks of any occupation for which you are suited for by training, education, or experience. Beyond the 2-year mark, to cross that threshold and continue receiving LTD benefits, you then have to demonstrate, again with the help of your treatment providers, your doctors, that you cannot perform the essential tasks of any occupation for which you are suited for by training, education, or experience. it's a broader test, it's a more difficult test to meet. Now, what insurance companies often do is they'll set you up to be seen by one of their doctors or one of their providers. Doesn't have to be a doctor, it can be someone else. In fact, oftentimes it is a non-doctor. And that individual is hired and selected by the insurance company to assess your claim, your file. Oftentimes they'll assess you in person. And then they'll prepare a report for the insurance company. Now remember, the insurance company obviously has selected that person because they're hoping that this expert is going to provide them with a conclusion that contradicts what your doctors are saying, that essentially helps the insurance company. It tells the insurance company that you are able to go back to some kind of other occupation. And that's what's happened, I think, in your case, Rhea. But you're saying that your doctors are saying you're not ready to go back to any form of occupation. Certainly no occupation that you're suited for. Well, I'll tell you this, as far as I'm concerned, your doctors trump. And the insurance company has done something that they always do, John, which is that they try to shake people off claim. And at that 2-year mark, around that 2-year mark, usually after a year and a half, just around that 2-year mark, that's when the insurance company, that's where there's a lot of activity on many files, because they try as hard as they can to get people cut off before that 2-year mark, because once you cross that threshold, it's that much more difficult for the insurance company to shake the person off claim. And it's really not a difficult type of a case for us to deal with, because really we go back to first principles, which is, what are the treating doctors saying? Think about it this way. If you're a judge and you have somebody come in front of you, and on the one hand you're listening to that person and they're treating doctors who've been dealing with them for months, if not years, and on the other hand you have a hired gun from the insurance company, as a judge, who are you going to believe? Yeah. I'm going to bet on the treating doctors, because they're not doing this for money. They're doing this because they care about you, because they're treating you. Right? So they're saying you cannot work, you have this disability because you are in fact disabled, whereas the hired gun has a motive here. They've been paid, selected, hired by the insurance company. So again, we deal with these cases all the time, and we resolve these cases all the time. And if, Raya, you, anyone else who's watching is in that situation, or you know somebody in that situation, please reach out to us. We can help.
Does Raya have to go, or just blow it off because it's the insurance company?
To the assessment?
Yeah.
You do.
Okay.
You do. Oh. There are caveats there. And in fact, we have a memo on ltdfaq.ca that deals with IMEs, what to do before, what to know before you go, what to do when you're in the IME, and what to do after, how to deal with this. But we tell people, look, you can go and get this information from our website, or you can contact us. It doesn't cost anything. We'll talk to you about your situation. Do you have to go to these assessments? Yes, you do. However, again, there are caveats. If they send you to a psychiatrist and they get a report that doesn't help them, the insurance company, in fact, it affirms what your psychiatrist or psychologist is saying, they can't just send you to another psychiatrist. They can't doctor shop. Yeah, but sometimes they try to do that, John. I mean, we've called insurance companies on that, and that's just not right. So yes, you do have to go, but again, there are limitations. They can't have you go and drive for 20 hours to see someone. Without maybe paying for your hotel overnight or something, so there are issues like that. So again, you have to make sure that if you aren't comfortable with what the insurance company is asking you to do, you check the policy, first of all, if they're entitled to do that, and number two, you can reach out to us at any point.
All right, short break. In the meantime, the number to reach out, as Savannah's mentioned, 1-855-821-5900, help@disabilityrights.ca. And after the break, 3 common misconceptions about LTD. That is on the way, so stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, thanks so much for sticking around. Disability Law Show continues. Sivan Tumarkin here, and John Scholes joining you every week. And information, always tons of it over this 30-minute show. Reaching out afterwards, just as simple, help@disabilityrights.ca and 1-855-821-5900. Feel free to call that number anytime you would like. Okay, Sivan, let's get into this. 3 common misconceptions about long-term disability claims. Number 1 might be my favorite on the list. Total disability does not, in fact, mean total disability. I love it.
What does that mean?
Yeah.
What is that?
Yeah.
We've talked about this endlessly. And by the way, John, we're saying 3 common misconceptions, but there are many misconceptions. I think one of the main ones I didn't even put on here was this power imbalance, how insurance companies want you to think that you have no power. One of the ways they do this is by controlling language. They're controlling the verbiage. You know, when you apply for long-term disability, especially if it's, you've never dealt with insurance companies before, certainly disability insurance companies, and you go to your doctor and you tell your doctor you're having issues, and your doctor says, you need time off, and then you find out through your HR manager or employer, whoever it is, that in fact you have short-term or long-term disability coverage, and then you start reading the application and you see this phrase, total disability. And when you say total disability, to a layman's, to a regular person, you think, you got to be in a coma. Yeah. You got to be brain dead. It's got to be horrible. Yeah. Total means everything. Total disability. That is not what it means in the context of long-term disability. Now, I have colleagues who think that the insurance industry has done this on purpose. Maybe, I don't know. I can tell you that it's a very, very confusing term. Not just to regular people, but doctors. Some doctors will tell their patients, I don't think you are totally disabled. But again, they misconstrue. What does total disability mean in the context of long-term disability? It means that you cannot perform the essential tasks of your own occupation for the first 2 years in general policies. Beyond the 2-year mark, again, the test changes. You cannot perform the essential tasks of any occupation for which you're suited for. Not just any occupation, an occupation you're suited for. And so it's really important to understand that when you're looking at total disability, the word total, strike that off. Strike that off. The question is not, are you totally disabled the way you may think total disability, is supposed to mean. It's whether or not you can do your job. Can you do your job? Can you do 10% of it? Can you do 90% of it? I mean, it can become a bit murky, but the reality is this. If you cannot perform the essential tasks of your occupation, whatever that is, a barista, an accountant, an engineer, electrician, if you cannot perform the essential tasks and your doctors are on board with you unable to do this stuff, well, then you should qualify under the criteria set out in your LTD policy for total disability. So take away from this, a total disability does not mean total. Yeah. It just means the essential tasks of your occupation or any occupation beyond the 2-year mark. And again, if you have any questions, that's when you reach out to us, right? And we'll tell you. Within a few minutes of talking to you, we'll be able to tell you if, in fact, you would meet that threshold, you would meet that test under your long-term disability policy. Misconception number 2, again, as Sivan said, there could have been 3,000, but we're doing 3 because we just haven't got that much time. Number 2 is insurers can't ignore what your doctors say. And they do this all the time. They ignore what treating doctors say all the time. Not only do they ignore, they do something that I think is even more egregious. They cherry pick from reports. So you'll do whatever you need to do. You'll provide the supporting documentation, the application, everything filled out by your doctor, your psychiatrist, your family doctor, your orthopedic surgeon, whoever it is. And the insurance company sends you back a letter saying, insufficient medical documentation, or they'll say, your doctor said that you're doing fine. Meanwhile, they cherry-picked that particular statement out of like a 3-page report that goes on to say that maybe you were doing fine on a particular day, but now you can't get out of bed or something. Right. So insurance companies oftentimes will ignore what doctors are saying, what treating doctors are saying. They'll disagree with them, even though these adjusters often don't have any medical training, certainly no designations. And the reality is that people then don't know what to do. In fact, I've had people calling me and emailing me saying, should I go to a different doctor? And I look at the documentation they've provided the insurance company and I say, no, your doctors are doing exactly what was asked of them. They've been very specific. They've expressly explained what is the nature of your disability, how it's impacting you functionally from working. It's absolutely fine. The adjuster is not doing their job. And so, again, for people to understand, and for doctors, anybody who is in the medical field or in the healthcare field, if you felt that frustration, with your patients, again, you can reach out to us as well. Don't break, patient-doctor confidentiality. But we've had doctors, John. I've talked to psychologists. I've talked to pain doctors who ask me, what do I do in this or that circumstance? And I advise them. And the reality is, insurance company may try to ignore their opinions, but they can't.
Yeah, because you can understand it being frustrating for the person who's insured, but once the doctor starts saying, what else do you guys want?
We have that all the time. And they get frustrated, they don't know what to do. Yep. In fact, we get referrals from doctors that we don't even know across the jurisdictions in Ontario, Alberta, and BC, where we practice. And it's because they don't know what to do anymore. They're at their wits' end. And it's really unfortunate because they have other patients they have to care for. They believe in their patients' rights to access this disability coverage, but they don't know what to do because the adjuster is just ignoring them. Well, we can make sure that they don't ignore them. There are ways around that.
Third misconception for the show today is insurers can't force you back to work before you are ready. Again, back to the doctors.
Yeah, insurance companies will often try to force you back to work. What they will say to you is that we believe that you are ready. We believe you're not as disabled as you are. Usually we see that a lot in situations where they've sent you to an assessment. And so they've sent you to see somebody that they hired to provide an opinion for them. And that person says that they believe that you're ready for a work hardening program or a gradual return to work program. You don't believe that's the case. Your doctors don't believe that's the case. But the insurance company says, look, if you don't do it, you don't participate, we're going to cut off your benefits. So people say, well, I have to go to work. I have to try. But think about this for a second. It's a catch-22. If you do it and you go back to work before you're ready, they're going to stop paying you anyways. And you're probably going to harm your health because you're going to work against medical advice, against what your doctors are saying. At the same time, if you don't do anything, the insurance company says, well, we're going to cut your benefits. What's the solution? The solution is for us to intervene right there and then. The solution is for us to actually communicate with the insurance company that here are the reasons why they can't do this, here's why you're not ready, and if they cut you off, they'll get a legal claim on their desk. Sometimes we're able to persuade insurance companies not to do this. Sometimes we can't, and then we hit them hard with a legal claim. And eventually they come to the table and they pay our clients what they're owed.
More information on these misconceptions or any more, just reach out to Sivan and his team, 1-855-821-5900. There's another website you can use. I mentioned it, mydisabilityquestions.com. We are going there for a question after a short break, so stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back. Thank you so much for sticking around. Last few minutes of the Disability Law Show. Let's get it happening. I mentioned another way to reach out to Sivan anytime and the rest of his amazing team, mydisabilityquestions.com. It's free. It's anonymous. Type in your question. You can even search it to see if it's been asked before. If not, leave it there and it will get answered. Odessa writes in and says, I've been on disability for 3 years. I understand from some of my old coworkers that my employer might be going out of business soon. What will happen to my LTD benefits if this happens? Question.
Odessa, nothing should happen to your LTD benefits, and I say that because once you're on LTD, you're now in the LTD system, so to speak. It has nothing to do with whether or not your employer is still in business or not. And frankly, I mean, the fact that you've been on it for 3 years now, assuming you have a regular policy, you're beyond the 2-year mark, really there should be nothing going on. The only caveat there, I think, is if your employer is the one that's paying you the LTD. And you do have some larger employers. Banks, for example, some of them are the ones who pay the LTD, so there could be complications there. But the reality is, under most circumstances, John, it doesn't matter what happens to the employer. Once your insurance company is paying you LTD, you've met the criteria for LTD, you're going to continue getting it irrespective of whether or not your employer is in business or out of business. That doesn't really matter.
Right. Samuel, email right here, help@disabilityrights.ca. I've been on LTD for almost 2 years after sustaining a serious back injury thanks to a nasty car accident. My insurer has told me to apply for CPP disability, but I'm not sure why I need to. What should I do?
Well, so this is a common request that insurance companies make, and frankly, it's really in most LTD policies that I have reviewed, there is a requirement for you to apply for CPP disability. Now, a lot of people, John, contact us and they're angry about the fact that they have to apply for CPP disability, and they ask why. And the reason is because, first of all, you have to under the policy. Number two, if you don't, the insurance company is going to guesstimate or estimate how much you ought to be getting from CPP disability had you applied and gotten it, and then they'll reduce your monthly LTD benefits accordingly. Now, why do insurance companies want you to apply for CPP disability? Because they get a credit for it. So if you are getting, in your case, Samuel, let's say $3,000 a month for LTD, and let's say you apply for CPP disability and you get $1,000 a month for CPP disability, you're not getting 3 + 1 for a total of $4,000. You're still getting 3, except that the insurance company is now paying you less, $1,000 less. So again, people get pretty upset by that, understandably so. But look, there are advantages to getting CPP disability. First advantage is that if you actually meet the criteria to get CPP disability, the criteria being that you have a disability that's severe and prolonged, it's going to make it that much harder for the insurance company to subsequently down the road cut you off on the basis that somehow your disability doesn't prevent you from working because the government has deemed you disabled for the purposes of CPP disability. It's number one. Number two, if you do get cut off by LTD, well, guess what? You have another income stream that is coming in from the government while we fight your LTD insurers to get you the benefits that are owed to you. So there are different benefits. There are other benefits as well. But again, if you don't apply for CPP disability, most likely the insurance company will guesstimate how much you're supposed to be getting and then reduce your LTD accordingly. In some more extreme circumstances, I've seen insurance companies actually say that, look, it's in your policy that you have to apply for CPP disability. You haven't. We told you to. You still haven't. You're in breach of your policy provisions. We're going to cut off your benefits altogether. Wow. Now, that's more extreme. Again, we've dealt with those. But the reality is you should be applying for CPP disability. There are more positives than negatives for applying.
And if you do end up getting it, is it arguably a tougher test than what your normal LTD policy would be?
Arguably, it's a tougher test, yeah, which is, again, depending on which lawyer you talk to. Sure. But the reality is this, that if the government has deemed you disabled, it's going to be more difficult for the insurance company to cut you off on the basis that you're not disabled. Right? It's just another arrow, that you have to shoot at them if you need to. Sure. And it's just one of those things where, if you don't do it, there's going to be that negative there, which is that the insurance company will most likely reduce your LTD payments in any event. So you should apply.
It's probably not a tough process anyway, really, when it comes to
not tough.
We look at the benefit to it, right?
It's not a tough process. And even if you get rejected from CPP disability, you can appeal that through the government, through CPP disability. And in fact, many of these kinds of appeals for CPP disability are actually successful. So you should absolutely apply for CPP disability. That's my generic advice. Yeah. But if you have any questions about your particular situation, again, feel free to contact us and we'll chat with you for free.
Samuel, thank you so much for the email, and that will do it for the show today. Reaching out like Samuel did, simple, help@disabilityrights.ca, mydisabilityquestions.com. Don't forget that one, free and anonymous, 1-855-821-5900. And for short, concise, easy to read memos on disability, LTDFAQ.ca. We'll catch you next time on the Disability Law Show.